Elsa Sardina, the new Secretary General and Managing Director of VanIAC, the Vancouver International Arbitration Center. Today, I have four very distinguished speakers with me today, two distinguished Americans arbitrators and two very well-known Canadian Arbitration Council. In the spirit of the panel's topic, I'll be very efficient with my introductions, as I'm sure you've all Googled our wonderful speakers. But just to remind you, Ludmilla was on VanIAC's new arbitration rules committee, as was Alex. She's a partner at Ferris with over 20 years of experience as counsel, and she writes the leading textbook in litigation in Canada. Alex is a partner at Faskins, and she is also a director on VanIAC's board. She specializes in commercial arbitration and is recognized by the who's who legal as a future leader. Dana Welsh is a very experienced arbitrator. She's been a lawyer for 35 years and has 20 plus years of experience as an arbitrator. Thomas Hannaran has 40 years of experience as an arbitrator and is the former global head of Sidley Austin. We welcome questions in the chat function, which we'll hopefully get to at the end of the session. We have a lot of ground to cover, so let's get started. Our first topic is about resetting expectations and the very important first preliminary meeting. Dana will take our first topic.
Well, thank you very much, Elsa. I'm delighted to be here. The lawyers in the United States, even in international arbitration, often approach arbitration as they would litigation. And when the parties have negotiated an arbitration agreement pre-dispute, their expectations are that it's not going to be litigation. Their expectations are it's going to be an efficient and economical process. So as arbitrators, it's really our job from the very first preliminary hearing to reset expectations and to manage the whole process so that it becomes efficient and meets the parties' expectations for when they negotiated their arbitration agreement.
Can the parties' arbitration clause be drafted in a way that promotes efficiency? I think Alex had some comments on this one to start, and then we'll go to Tom.
Yeah, so I think having the right arbitration clause in your contract from the outset saves the risk of having disputes on procedures and getting bogged down in procedural fights later on. And so I don't know if we're able to pull up VanIAC's model arbitration clause, but what each institution typically has is a model arbitration clause on their website that you can borrow, and then you can play around with it. And what I think is a good practice tip is if you have a contract that's dealing with parties from two different jurisdictions, so for example, Canada and the US and Canada have different approaches to discovery. For example, in the US, depositions are much more common and much more numerous, whereas in British Columbia, you don't have a right to a deposition. You have to seek leave for that. In the litigation context and in the arbitration context, most rules provide for limited document discovery or no oral discovery at all. And so if you want to either have some discovery or you want to limit how much you have, you may want to include something in your contract that deals specifically with discovery, even if it's not in the model clauses that you see on institutions' websites.
Yeah, I would echo all of that and just add a couple of thoughts. Sort of things that you observe that create problems down the road. Sometimes the clauses don't identify what the governing law is. Maybe it's buried somewhere else in the contract, but give some thought to that, both the substantive law and procedural law. For example, if you're in the United States, in California, where Dana and I work, you might look for, the law of this agreement is subject to the law of California and the Federal Arbitration Act, something like that, because it avoids issues and arguments down the road, which can make a difference in how the case proceeds and what the outcome might be. Second thing to take a look at when you were drafting these clauses is, have you clearly identified what issues are subject to arbitration? They're often very vague, and sometimes they'll say things like, any issue related to the performance of this agreement, which might sweep up a lot of things that the drafters didn't have in mind when they were writing this. So give some attention to that. You may intend something quite broad, but maybe not. So give some attention to that. Also think about whether your agreement includes some limitation on remedies. You know, sometimes people who are thinking about arbitration say, well, arbitrators can give any kind of remedy they want. And while there is, generally speaking, a fairly wide discretion about remedies, if your contract has a limitation on that, you may have expectations and understandings that are cross purposes with each other when you're putting your substantive provisions next to your dispute resolution provision in the same agreement. So give some attention to those things and think about how a streamlined, compressed, get to the point process will really work out in practice for you. Yeah, and maybe get some advice from people who have been doing this for a while before you sit down and start writing an arbitration agreement.
Yeah, if I can just add from an arbitrator's perspective, the first thing that we look at is the arbitration agreement when we start a case. And we get a lot of really what I call sick arbitration agreements, where the transactional attorneys have not put a lot of thought into it. So we'll say things like the federal rules of evidence apply, the ICDR rules apply. Well, those are two contradictions. Know that an arbitration agreement is a contract, just like any other contract. And when you come to an arbitration, the parties have the ability to modify an arbitration agreement to make it work. And of course, if the parties that don't agree on a modification, then you just have to work within the confines of that arbitration agreement.
That's a great point that leads us to our next topic, which is, are there certain processes, considerations, perhaps apart from parties agreeing to things, that contribute to efficiency in the appointment of the arbitrator?
So I'll start there just with the new ICDR rules are pretty interesting in that they have the presumption of the appointment of only one arbitrator as opposed to 3 arbitrators. And I know that arbitrators can get pretty expensive, but the presumption is only one arbitrator at this point, unless the administrator determines that the size, complexity, or circumstances of the case mandate 3 arbitrators. And of course, if there's an arbitration agreement which says we're going to have a panel, then that's going to be the presumption. Again, subject to that you can always modify your contract to make it more efficient to only appoint one arbitrator. But I think there's some differences in terms of Canadian practice and US practice. We don't have a lot of non-administrative arbitrations here. Most arbitration agreements include a provider, whether it be ICDR, AAA, JAMS, CPR, whatever. But I think the practice is different in Canada. Am I right, Ludmila?
Absolutely. So there are very often parties and their counsel who decide on not having an administered arbitration, and they think it might foster efficiencies, and certainly in the appointment of the arbitrator, it may very well not. So an advantage of an institution that can step in is that it has a panel, it has a roster of arbitrators who are known to it and have gone through screening processes already, and that the arbitral institution can step in and circulate lists, for example, of arbitrators that parties can consider, but it has that mechanism in place. So the contrast, for example, when we're in the international realm and you're thinking about, say, in British Columbia, just falling back to legislation or something that exists in the absence of rules and an institution that can step in. The default under our International Commercial Arbitration Act, although a very sophisticated act in general, is 3 arbitrators unless parties agree otherwise, and that you may actually have to go to the British Columbia Supreme Court, the Chief Justice thereof, to get help in the appointment process. So compared to that, an arbitral institution that can step in with rosters and a process can be very helpful in terms of efficiency.
And not only that, when you get to a problem of what if it's a non-administered arbitration, which means the arbitrator is administering it, and the parties say, well, you have a conflict. Who's going to rule on that conflict if there is no arbitral institution? The arbitrator, which raises problems in and of itself.
I agree. And this is a perfect opportunity for a shameless plug for VanIAC's administration services, which are second to none. I spent my career sort of working in arbitral institutions. So I'm bringing best practices to VanIAC. So please let us administer your arbitrations and let us help you with your appointments with our roster. Once the arbitrator is appointed, ideally by an arbitral institution or by the agreement of the parties, or in a panel of 3 by the co-arbitrators themselves, can efficiency be promoted in this this very important first procedural meeting? Tom, take us away.
Yeah, let me kind of kick this off. From my perspective as an arbitrator, the first thing that I would encourage the lawyers to do before that preliminary hearing, that first hearing even occurs, is talk to each other. Arbitration is a process governed by an agreement. And while we said earlier, pay attention to what the contract says, read the rules that you've agreed to if you have, pay attention to what the governing law is. Sit down and talk to each other about how you want this process to unfold, because you have control as a party to setting what the schedule is going to be within some limitations, deciding what the issues are that you want the arbitrator or the tribunal to decide, agreeing on what kind of information exchange or discovery process both parties want. And in general, what parties agree to, the arbitrators are for the most part going to let you do. You may get some pushback. Dana mentioned earlier, you see an agreement that says, the federal rules of civil procedure in the United States. Well, that's pretty broad discovery, and you may get some pushback from an arbitrator, even if you have that kind of provision in there. But sit down and talk to each other. Talk about what the schedule you want is, as I said. Make sure you have some common understanding about what the issues are that you want the arbitrator to decide. You'll frequently see a claim for arbitration demand or a submission statement that may be short or it may be very long, but it's not entirely clear exactly what the issues are. Because at the end of the day, the arbitrator has to decide something and write what the arbitrator has decided. So make sure that there is some common understanding of what the issues are, or you've defined a lack of agreement about what the issues are, because you want to know that up front as well. Those are sort of the initial things I think about. Alex, other things that pop up from your perspective as counsel?
Well, so one question that I have actually for our 2 arbitrators, for Tom and Dana, that I run into as counsel is, should it's depends on each time I have a case in a different arbitrator. Do the arbitrators, or do the 2 of you prefer to take the lead on setting the agenda for the first procedural conference and asking the parties, to the extent possible, to draft a joint procedural order on the points they have in agreement together, and then to flag the areas where they don't agree? Or as the arbitrator, do you prefer to actually draft it yourself, have the pen on that, and take control of that?
So I'll take a first hand at that. I always distribute an agenda that is tailored to the case before the procedural conference. And I'll distribute that to the parties when the procedural conference is set. I will say, get me your agreements and disagreements on this agenda, which not only includes schedule, but includes what's the governing law, what's the venue, all of the issues that may arise. Do you want to bring dispositive motions? When do you want the hearing? How many days? What kind of information exchange do you want? And I will have the parties submit to me their agreements and disagreements. It makes the first procedural conference so efficient. And then what I do is I will distribute a draft procedural order for the parties to mark up if they have disagreements about the dates. Tell me, get it to me a couple of days later, and boom, away we go. Tom?
Yeah, I do something similar. Like I suspect a lot of us, I have a kind of template preliminary hearing order, which includes a lot of boilerplate and a lot of blanks to fill in. For example, there's a schedule at the end of it with, some things that I know are going to be there, and dates are blank, other things that may or may not be there. And I will typically send that out to the parties in advance, maybe a week or 10 days, depending on how much time there is, and say, talk about these things. And there's one blank in there for preliminary issues to be decided, things like jurisdiction. And I don't tell suggest what they might be, but things like, does the arbitrator have jurisdiction at all, or over everybody, or over every issue? There may be statute of limitations things that somebody wants to raise early, but a slot there to prod thinking by the lawyers about what things should be considered sooner rather than later, and then tell them, think about, as Dana says, what you are in agreement on and where you have disagreements, and then let's talk about it. And generally, those things get worked out during the course of that preliminary hearing, which might last an hour, give or take, depending on how complicated it is, how many parties there are. And then I will frequently send out a draft form of that order for parties to tweak as they may think appropriate. Sometimes my notes won't be complete and I'll forget something and somebody will remind me of that. So I think there's no downside in giving the lawyers an opportunity to take a look at the scheduling order, because it drives the case. It is literally your roadmap for where this case is going to go and how quickly. Take a look at that, and then it'll get signed within a day or two after I get some comments from you.
And I think from the council perspective, it's important to have, to the extent that, especially where the arbitration clause is quite general and doesn't include much specificity to it, and there's a lot more to work out in the first procedural order. It's important because, as you said, it's the roadmap and governs the rules of the game for the parties moving forward. And of course, there may be further procedural orders as you go, as various different things arise. But to the extent that everything can be covered in that first order, it's extremely helpful.
Right. And my practice is literally to map out every single action that we can anticipate at the first procedural conference. So, what information exchange do you want? When do you want it? Do you want to do initial disclosures? Let's map out a dispositive motion if anybody is anticipating bringing one. So it's not only when are we going to have the evidentiary hearing, but each step of the way, what is the schedule?
And it makes it so valuable to have experienced arbitrators like Tom and Dana who have these ideas in mind and can communicate them, whether by agenda in advance or at the procedural hearing itself, to maybe let counsel know who haven't, for example, done an international arbitration before, what are the sorts of things to be thinking about? Because I think a lot of us as counsel, when we're going into this without experience, it's not necessarily that we wouldn't want to embrace any efficiencies that are out there, but we just don't know that they're possible, or we don't know what certain steps might entail. And so it's very helpful. And I found as counsel how much I've learned over the years from actually taking the time to listen to what arbitrators are telling me at these initial meetings, because it may not be determinative. It may be a collaborative process in arriving at a schedule, but there are always good ideas exchanged to be mindful of.
Yeah, let me add one other thing that I started doing a few years ago. We'll set a schedule and everybody will be in agreement on the schedule, more or less. There are things there that affect me as an arbitrator or the panel as a group. And I tell the parties, those dates are kind of fixed. If there's good cause to change them, we'll change them. But view those as fixed, and your clients should view those as fixed. There are other dates, like an initial exchange of documents, completion of exchange of factual information, whether or not it includes depositions, disclosure of experts and their reports, if that's what we're going to do. There are those dates that don't have an impact on my schedule. And I tell the lawyers, you can change those dates if you want. Let me know if you're doing that, but I'm not going to micromanage your schedule. So if you agree to disclose your experts 20 days later than agreed, that's fine with me, as long as it doesn't affect our final pre-hearing conference and the dates for our evidentiary hearing. I'm indifferent to that. But I want the lawyers to take control of the case, but within some structure that allows us to move forward efficiently.
That's such a great point. And this really shows the importance of arbitrators being decisive and having managerial skills. At that preliminary conference, you're guiding the parties towards these efficient sort of practices, turning their minds to these important issues and trying to seek agreement where appropriate, where possible.
Yeah, I'll also underscore a word Ludmila used a moment ago about collaborative. pick up
Yes.
on Dana's point about resetting expectations. I think arbitrators expect the lawyers to work together in an arbitration case much more collaboratively than they would in a judicial setting, where there's a defined set of rules, there's a defined set of judicial procedures, and it doesn't require a whole lot of collaboration between the parties and the lawyers particularly. Arbitration is different. We really do expect the lawyers to work together to create a process that's going to work well for their clients.
Right. You're right. One thing that's different between a judicial process and an arbitral process is the arbitral process is the parties' process. The parties agreed in a contract to arbitrate, and they have to agree on the procedure and they have to agree on the schedule. So I know that arbitrators vary in terms of how they handle things, but my firm belief is that it's a party-driven process. So if the parties come to me and say, for example, we each want 10 depositions, I will say, wait a minute, that is out of bounds and it's really not what arbitration's about. So let me talk you down from that. Let's start with 3 depositions and then see if you need more. But if the parties still insist, we each want 10 depositions, my belief is that it's the party-driven process, and it's not the role of the arbitrator to say that's impossible.
Yeah,
Tom,
I agree with that entirely. And I've had exactly that experience where the parties had agreed to the federal rules of civil procedure, and they said, that's what we agreed to, and that's what we want. That's what we're going to do. And I said, okay, but you understand the rules allow the court, which in this case is me, to impose some limits on that. So why don't you go think about whether you really need 15 per side? And they came back and said, well, 3 will be enough. And that's what happens. That's what you expect to happen. And that is part of resetting the expectations that lawyers have.
This leads really well actually into our next topic, which is about sort of what limitations should arbitrators perhaps encourage, particularly when it comes to document discovery in arbitration. Dana has already pointed out some marked differences between sort of the American approach and the Canadian approach. And I thought it would be good. Perhaps you can hear from Ludmilla and speaking of the Canadian experience when it comes to restricting document discovery.
Thanks very much for that, Elsa. And it's interesting because Canadian lawyers, to those of us who are used to practicing in the courtrooms, have, even though even our courts are trying to narrow the range of documents that are ultimately available up front, we've got the sense of we're going to be able to look at lots of documents. So we're going to find the smoking gun somewhere and maybe build our case after seeing the documents that come in. But of course, it can be an enormously inefficient process because you end up with, and Tom mentioned this during one of our prep sessions, you end up with boxes of documents where most of it is not relevant. Most of it's duplicative and it doesn't really get you anywhere. So arbitration, if you can structure it this way, can be a perfect opportunity to achieve savings in the documents that you ultimately have to wade through as counsel, while still having a very focused and targeted set of documents that you really need both to build your own case and to challenge the other sides. And so I think the sorts of techniques that are becoming increasingly accepted among counsel who at least repeatedly do arbitrations in British Columbia, and Alex is among them, are things like perhaps having your case presented by way of statements of case, where you actually present witness statements and arguments up front, and as part of that, transmit to the other side the documents that you yourself are relying on. And then go through stages where the other side, perhaps on seeing that and seeing the gaps that exist in its own knowledge, actually make a limited set of requests for documents that are still outstanding in its view that would help or hurt its own case, and potentially even going through and going through a process where the arbitrator decides which of those requested documents should actually be provided. And I know Dana had mentioned the evolving, I think, terminology in this regard as well, or I've heard evolving terminology in this regard as well. But Redfern schedules, the sort that VanIAC has on its website, requests for document schedules, are often a good means of written back and forth, rather than necessarily having to have an oral motion in front of an arbitrator where a request is set out, the grounds for it are set out, opposition is set out, and the matter can be moved forward quite efficiently that way. So yes, lots of courtroom baggage in this area, but lots of potential for evolution and efficiency, I think, if done properly.
Mhm. Tom?
Yeah, just a couple of thoughts about that. Setting aside depositions for a moment, ignoring those and just focusing on documents. As most of the rules do, I think there's an expectation of an initial and approximately voluntary exchange of documents on which you, the party, intends to rely. It's generally the phrase that you'll find in the rules, both the VanIAC rules, the AAA rules, I think the ICDR rules as well. And get that done, on a voluntary basis. Frankly, Rule 26 under the Federal Rules of Civil Procedure is approximately that as well. To get that done on a voluntary basis and set some kind of deadline for that to occur if it hasn't already started. And then what I generally do, and I just happen to pull up my sort of template order here, which says that, look, and I will tell the parties this, you can ask for additional records that you think exist, you're confident that the other side has, and they are unquestionably relevant to the outcome of the case. And the reason I say the outcome of the case is to refocus thinking away from what lawyers in the US at least are trained to think about is relevant to the subject matter of the litigation. There's very little that's not relevant to the subject matter of the litigation. But there are lots of things that are not relevant to the outcome of the case. And the idea is to force people to do that. I also tell the lawyers that you don't need a formal motion with, set out what the request was, what the response was, what you actually got, and what the reasons are, and cite, 15 pages of case law and all that sort of things in a brief. Put it in an email. If you can't work it out, and by the way, there's maybe 1% of the cases where you might reasonably not be able to work it out. But if you can't, send me an email. Both sides will, send that kind of notice. And if I think I need to hear from you, I will let you know. Otherwise, I'll give you a ruling on it. And the idea is to avoid a lot of the needless and often mindless letter writing that goes back and forth between lawyers in a judicial setting. Set aside the formalities that are often required and are part of the lawyer's normal mindset. Put that aside. Focus on what you as a trial lawyer really need to win your case. And if you are looking for the needle in the haystack and you think you need to have the whole haystack to find it, just ask for the needle. Don't bother us with thousands of pages of hay. Ask for the needle.
If I can just jump in with a couple of other points, I completely agree with initial disclosures. I set them for 30 days after the first procedural hearing, the first preliminary hearing. 30 days, documents you're going to rely on, and then RFAs are permitted to the extent that the initial disclosures are inadequate, but only after you review the initial disclosures and they're inadequate. There's one other important point, is that what piece of arbitration or litigation does not include electronic discovery at this point? They all do, and except for the very smallest case. So I require the parties to meet and confer on an ESI protocol, sometimes after the initial disclosures, because then they know the scope of the case, but as soon as possible. And I have guidelines for the parties, what issues need to be addressed. And the parties need to think about ESI as narrowly as possible. Think about your search terms as narrowly as possible. Think about what custodians you really, really need and who's going to be duplicative. And I will supervise that process, because the information exchange can totally spin out of control unless there is a very carefully managed ESI process.
Yeah, I agree with that. And there's a provision in my template order which addresses that. I can only think of one case where the parties were at loggerheads about search terms. And we talked about it and kind of worked it out so that the problem disappeared. But a lot of these issues, which can occupy a lot of the time and the attention of the lawyers, can be resolved if you sit down and take 30 minutes to talk to your arbitrator about it. Skip the paper writing campaign, work hard on avoiding the problem. And if you can't, talk about it and you'll get a decision and move forward.
You've just highlighted one of the fundamental differences between a court process and arbitration, just the fact that you can do that, take advantage of that as counsel on behalf of your parties and talk to your arbitrators. That leads nicely to kind of a more specific aspect of, whether or not to restrict this in arbitration is can and should oral examinations for discovery and depositions, should those be restricted? And sort of what are the differences in the American perspective versus the Canadian? Perhaps Dana, do you want to start with that one?
Sure. Well, this is not a shock to everybody who's not an American, but Americans love depositions. They love depositions. And, if you try and tell an American lawyer there are not going to be any depositions here, they kind of freak out. And it's basically, it basically is because lawyers like to control everything. They like to know everything before they go into a hearing. So in an international case, the ICDR rules specifically say depositions, requests for admissions, and interrogatories are generally not allowed in international arbitrations. That's the rule. In domestic arbitrations, the rules are silent, and American lawyers will come in thinking that they need depositions. So in an international arbitration, I would really try and get the American lawyers to adjust their expectations in terms of what's needed, but very few American lawyers will conduct an arbitration process without feeling like they need some depositions. That's just what the practice is here. And it's what I tell people is, what do you need to hear before the hearing? And why do you need to hear it? Why can't you get it through document discovery or some other means? Why do you need a deposition? But American lawyers are pretty set on the practice, and I know it's different than everywhere else in the world.
And maybe what I'll just add to that is the whole point of why arbitration is supposed to be different than litigation, and why examinations for discovery, which are what we have in British Columbia, or depositions are supposed to be the exception and not the rule in international arbitration, is because the point of arbitration is to get to a determination on the merits as soon as possible. And one of the keys to the efficiency of arbitration is the emphasis on adducing evidence early on in the process through your memorial of fact and law, through your witness statements, through the documents that are referred to in those witness statements and your memorial. And so by adducing all that evidence on the early part of the case, it's supposed to avoid needing to do what the litigation process is, where you put your pleading in, then you have to do documents, then you have to do your examinations for discovery or depositions, and then you get to a trial. And so they're used more in litigation because essentially nothing is happening before trial, or at least that's what happens in British Columbia. You may wait 2 years before you're even getting into an examination for discovery. And so you need those tools in your litigator toolbox to discover your case and to discover the other side's case and the strengths and weaknesses. If you do international arbitration the way it's meant to be done, which derives out of the IBA rules of evidence that then is incorporated in a lot of the institutional rules, it provides that discovery process and the fact-finding process early on so that you can get to that merits hearing sooner.
That's such useful advice from counsel perspective. Can we hear from our arbitrators on tips in terms of dealing with motions?
So, yeah. Well, maybe I have a slightly different perspective on motions. Both the AAA and the ICDR rules, and I'm not sure if the JAMS rules have a similar provision, this has to do with the dispositive motions, require the parties to get permission from the arbitrator before they can bring a dispositive motion. And specifically in Article 23 of the ICDR rules, it says a party may request leave from the arbitral tribunal to submit an application for a disposition of any issue. And the standard is the tribunal shall allow a party to submit an application for early disposition, which means a dispositive motion, if it determines that the application A has a reasonable possibility of succeeding, B will dispose of or narrow one or more issues in the case, and C, consideration of the application is likely to be more efficient and more cost effective. So what does that mean? What I do is I have a two-step process. I say, you got to write me a letter brief and tell me why you're likely to succeed. And I'm going to let the other side oppose it. And only then, if I determine that you've met the standard, will we go into a dispositive motion. There's one other consideration that I adopt when I consider dispositive motions, and that is that there are very few grounds to overturn an arbitral award, very few grounds to get it. It's very different than an appeal process in a court setting. So when I look at a dispositive motion or application for dispositive motion, I have to be absolutely, I wouldn't say 100% certain, but pretty well convinced that that this is going to be efficient and it's really going to resolve the case, because that party doesn't have a second bite at the apple in an appeals court. So that's how I approach dispositive motions: is get permission. It's an efficient process because it's going to weed out motions that are not going to succeed. Sometimes counsel groan because they have to go through two steps, but they really avoid the whole process of filing something that is not going to be successful. In terms of other kinds of motions, like discovery motions or non-dispositive motions, if we know what the issues are at the first conference, like if it's a jurisdictional motions, I'll set a briefing schedule. If it's a discovery motion, I will have in my first procedural order, the parties must meet and confer before they come to me with any kind of discovery motion. And I'm just like Tom, I'll do it as efficiently as possible. Drop me an email, give me a call. Let's get it done right away. Let's not wait and let's not delay the process because of these motions.
Yeah, I agree with everything Dana said. I think dispositive motions are less uncommon than they used to be, which is a fancy way of saying you see more of them, or at least more requests. But my kind of benchmark, and I talked to the lawyers about this at the preliminary hearing, is, look, it should be a clear question that it's just a matter of interpreting the law or applying the law, or interpreting a contract in which there's no real dispute between the parties about what it says and what was intended. And the only question is, how does it apply to these facts? And no really dispute about that. And resolution of that, granting it, will make a difference in the case, either because it resolves the entire case, or it resolves a critical issue in the case, which is tied to a material reduction in the amount of damages that a claimant or a cross-claimant might be claiming. So that you not only got to win, but it's got to make a difference. If you're going to have the same witnesses for a hearing and it's going to last just as long, and the damages are going to be exactly the same as they would be if the motion weren't granted, then why are we spending time on this? We might as well just deal with it during the course of the hearing. It'll be much more efficient. But there are other things that are different, jurisdictional issues. Can I decide something? Do I have the authority under your agreement and under the rules and the statute to decide whatever it is you're asking me to decide? Is there a statute of limitations issue? Do we have a party that you have named here, is named as a respondent, who's not a party to the agreement? Under sort of general principles, I probably don't have jurisdiction over that person. There are exceptions to that, and there is a process for resolving those kinds of questions. But those are things you want to decide early on. And if the parties disagree about it, that's an appropriate motion process. But again, it's a very expedited and simplified motion process.
Mm-hmm. What do you think about having direct evidence adduced in writing? Does this promote efficiency? Perhaps Dana can take this one.
It does promote efficiency, and certainly that's the presumption under the ICDR rules, is that direct testimony, and in fact witness testimony, is going to be taken by written witness statements. It reduces the time that you're in the evidentiary hearing. Mm-hmm. Having said that, I will tell you that, and I'm going to harp on American lawyers again, most American lawyers will resist that process. and will say, we don't want to adopt that process. We want to have direct examination, and we want to have everything in the hearing live or on Zoom. We do not want to submit written witness statements, but it's an international procedure that really promotes efficiency. And I think
let me add one other observation about that. From the arbitrator's perspective, if you have written witness statements in advance of when the hearing is technically and formally beginning, it gives me a much better understanding of what the issues really mean, where the evidence is, because one of the things that arbitrators do that judges generally don't is ask questions of the lawyers and of the witnesses, and those questions may come at any point in the process. And to the extent that I am better informed about how you as counsel see your case, and I've learned that through your written witness statements, that enables me to ask better questions, and frankly gives you, the lawyer, a chance to either say, yeah, he gets it, or no, you didn't get it. Here's what the point is. And if I'm the lawyer, I want to know that my arbitrator or my panel understands my position. And if I'm the arbitrator, I want to know that I got it wrong and I don't understand your position. And written statements help to inform my thinking well in advance rather than as the hearing unfolds. And I think that's an advantage for counsel, frankly.
And if I can just add, VanIAC's rules, our international rules, provide that unless otherwise agreed to by the parties or directed by the tribunal, the direct evidence is done by way of written witness statement. And that unless a party requests an oral hearing, the arbitrator or the arbitral tribunal shall decide whether to hold oral hearings for the presentation of evidence and arguments. And so unless you agree to something different, the tribunal orders something different, or your arbitration agreement says something different, your direct testimony for your witnesses under VanIAC's rule is going in by writing.
And I think Alex and I both have the experience in British Columbia, which I think sounds quite different from the experience that may still be occurring in the United States, where local counsel are becoming more and more accepting of a written witness statement as a means of facilitating the arbitration, and perhaps being the corollary to not having oral examinations for discovery, where they avoid the ambush of unexpected evidence by at least having seen the other side's direct evidence.
Yeah, and
the hearing.
I think the reason is culturally in British Columbia, because we've had summary proceedings, like summary trials, for so long, where the evidence is done by way of affidavits for direct evidence. I think our bar is a bit more open to doing things like direct testimony through witness statements in an arbitration, domestic or international.
That's a great point. Yeah.
That actually leads quite nicely to one of the questions that's appeared from Gary Benton, which is requesting that we cover the VanIAC International Commercial Arbitration rules, our new rules that came into effect July 2022, and for their use in arbitrations with US parties. Alex just touched upon a point, the fact that the default is written evidence. Are there any other points that you would raise about using the new rules with US parties or with a US seat, which is possible?
Yeah, and I'll turn to Ludmilla after this, but I think that, so there's nothing preventing you from using VanIAC's rules for where you have one party that's Canadian, one party that's American, or two completely international parties that are outside of Canada. Our center is equipped to deal with international cases, and we've been building our international roster of arbitrators to be able to deal with those disputes. Our rules, what you'll see if you go through them, and I don't think we're gonna have time to cover a summary of all of them, but there is a Kluwer arbitration article that that a number of us wrote, including Ludmilla and I, on a summary of those rules. So that may be helpful, and I may have Ina drop the link to that in the chat for people, since it provides that summary. But you'll see there the types of procedures that you would expect to see in modern international rules, like the ICDRs, for example, or JAMS, are going to be fairly similar in VanIAC's as well. And so the types of things that you're used to seeing that are crucial will be there. But then there are these slight variations like narrowing discovery, especially on documents, and having the direct evidence be in writing. And then there are procedures around emergency arbitrators, interim measures, and those types of provisions that you may find interesting to use in certain cases.
That's great. Thank you so much. And perhaps back to the arbitrators, to Dana, would you ever suggest a written only process?
I would suggest it if really the issue is a dispute about the contract, or, you know, the oral testimony is not really pertinent to the particular issues. That happens sometimes in technology disputes. I have a current case which it really is all about a differing interpretation of the contract. And it just makes perfect sense to do it on the papers. We really don't need testimony. We just have to look at the contract and have the parties submit the law around the contract. So, you know, the rules contemplate that for smaller cases, document-only procedures can be adopted, but it also can be adopted for the appropriate case. And of course, you have to get the parties' agreement that they're willing to submit on the papers.
And just to contrast that, sorry, go ahead, Tom.
Yeah. I'm sorry, Alex, I cut you off.
No,
there.
go ahead. No, you go ahead, Tom.
I was going to say, I'm generally not a fan of it. But, you know, as Dana said, there are cases where testimony is just not particularly important. It's not going to shed much, if any, light on the issues. And all you really need to do is read what the parties have written in their business records and then make a decision, because they're just reading those records differently for whatever reason. And it can be very quick, but the parties really need to be comfortable that they don't need someone to tell their story to put those documents in a context. And I think that's pretty rare that the lawyers will be comfortable with that. But, you know, for the right case that has a really discrete issue, you know, maybe it's something that comes up in the course of a larger ongoing business relationship, or just at loggerheads about one particular aspect of that relationship, and we want to get that decided so we can all move forward on a common path. Yeah, that might be appropriate for something like that.
And so what I wanted to just flag was, and we'll talk a bit about expedited procedures in a moment, but VanIAC's expedited rules and many of the center's rules provide that unless otherwise agreed to by the parties or directed by the tribunal, the materials are done by way of writing only. And so it's the reverse, where it's not that the parties have to agree for it to be in writing. It is in writing unless the parties agree otherwise, or the tribunal directs it, that there be an oral hearing. And Dana had mentioned that document only procedure in tech cases is something that we're seeing that's a bit more common. Just to flag for people, there's an UNCITRAL working group that's held a colloquium to deal with issues related to dispute resolution in the digital economy with technology disputes. And those draft provisions include various different techniques for speedy resolution that are significantly speedier timelines and procedures than we see even in expedited arbitrations. So, for example, one of the draft provisions provides that all materials that support your case, so all your documents and any evidence that you want to rely on, have to be submitted within 5 days of the initial case management conference. And that the award has to be rendered within 20 days of the constitution of the arbitral tribunal. There can be an extension to 40 days, exceptional circumstances to 60. And if it's not done within that, the arbitrators or the tribunal gets a reduction, a sliding scale reduction on their fees. And one of the other draft provisions is that the dispute is done entirely in writing, and that's to allow for these short condensed timelines. And so I think we are going to see more cases in writing in the technology and the digital industry space as these types of working groups start advancing those rules.
Thank you so much. It's so interesting to see that these tech disputes are using arbitration clauses perhaps more frequently than other areas of law as well. So that's exciting to see as well, sort of cutting edge. I don't want to run out of time to talk about the oral hearing and get our US and Canadian perspectives on what can be done to make that efficient. Do we want to start with Tom, perhaps?
I guess my advice to the lawyers about the hearing from the pre-hearing period to the post-hearing period would be get to the point. Rules of evidence are not important. There's a bias, if you will, in favor of hearing whatever evidence you want to put in front of the panel. With some exceptions, if there's a privilege issue, for example, you pay attention to that. But things like hearsay, authentication of documents, don't worry about those things because they're just not going to be a factor. As an arbitrator, you tend to take the evidence as it is, and part of the reason for that is one of the ways that an arbitration award can be vacated is if a party can make a persuasive case that they were denied the opportunity to present all of the material relevant evidence that they had. And so there's a predilection, I think, on the part of arbitrators to I'll listen to whatever you want to tell me, and I'll decide whether it's persuasive and how much weight to give it and things of that sort. So my advice to lawyers who are trying a case in arbitration is get to the point when you're examining a witness, anticipate that you will have questions from the arbitrator or members of a panel or tribunal. Take those as opportunities, not as a interference with your well-laid, carefully crafted plan for how you're going to present your case. Take it as an opportunity to be persuasive in the middle of the hearing, perhaps, maybe in the middle of a witness's testimony. If an arbitrator says to you, I'm not following where you're going with this, take the opportunity to get that arbitrator on the same track with you. In terms of what you do pre-hearing, a pre-hearing brief, for example, lay out clearly what you think the issues are that the arbitrator needs to decide. And I know we talked about this in terms of preliminary hearing, but sometimes those evolve a little bit. So be really clear about that. If there are some critical legal cases or statutes that you think drive and govern the outcome, make a note of those. And for the post-hearing, whether you're going to do briefs or you're going to have argument, I think most of us try to give the lawyers some questions that we have before they write a brief or before we have an oral argument. What's on my mind that I'm struggling with, things I don't understand, and I want to make sure I do. So take those as another opportunity to make sure that the arbitrator of the panel understands what your position is, and then address those. I mean, when I do post-hearing arguments, it's not an argument. It's not a stand-up set piece by the lawyer. It's a conversation. Here's what's on my mind. Here's what I want to make sure I understand about what your position is. And we may debate that a little bit. I may play devil's advocate with you. And you get, if you have a panel or a tribunal, you will get questions that come from different directions. It may reflect different ways of thinking about things, because we all come to the case with a background of our own experience. And so take the opportunity to have that conversation, that dialogue with the arbitrators.
And if I may just add one more facet, or another of the facets that may come up in terms of planning out from counsel's perspective, what happens during the oral hearing, that may in part reflect how much is done in writing, of course, in advance. So Alex and I have the common practice of the written witness statements being adduced as parties' direct evidence here in British Columbia, both domestically and internationally, in terms of the type of arbitration it is. And so if that happens, it may very well be that at the actual oral hearing, a witness may or may not be asked to attend, although you should, of course, always be prepared that that witness who submitted a witness statement will have to, and then have a very brief direct examination, kind of more of a warm-up for cross-examination to follow. And as Tom said, the kinds of questions that should be coming as part of that questioning at the hearing should be quite focused and targeted. And I think increasingly at our end, arbitrators are expecting parties and their counsel not to waste time with extraneous questions, but really focus their attention on what matters to their case, which can in turn lead to a shorter hearing, even though it's very unfamiliar to those of us when we're sort of starting in the arbitration context, to have this unfamiliarity, and the fact that your witness isn't going to be, able to expand at length on their direct narrative. It's a bit unfamiliar, but can be very efficient.
Yeah,
That's
I want to emphasize one other thing, and that is because the rules of evidence, the U.S. rules of evidence, don't apply. I don't know what the Canadian rules of evidence are, whether there's hearsay is impermissible in court. They don't apply. So what I do at the final status conference before the hearing is to tell the parties, if it's on the exhibit list, it's presumed to be admissible. You don't need to lay a foundation. You don't have to have an exception to the, to the business record rules. So everything's presumed to be admissible. It gets admitted through a witness or through stipulation, but we're not going to have to lay a whole foundation. Is this a business record? Did you authenticate it? And I'll deal with objections as they come. And that really saves a lot of time at an evidentiary hearing. The other thing that appears in the new ICDR rules is that the arbitrators have the authority to order the hearing to be held remotely by Zoom. And some lawyers really resist that, but I think we've learned through 3 years of the pandemic that Zoom hearings are actually pretty effective. And if the arbitrator really thinks, particularly in the international context where people are spread all over the globe, that a Zoom hearing or some other kind of remote hearing would promote efficiency, we have the power to order that, even if the parties are not that happy with it. So that's just one thing to take into consideration. It's a very efficient procedure.
Yeah, I'll just add one thing on the exhibits. You will frequently see parties submit pre-hearing a joint exhibit list and tell them eliminate all the duplicate exhibits. There's not a claimant's exhibit and a respondent's exhibit. At least for me, it's just an exhibit number 1 or wherever you want to start, and it runs through 250, let's say. During the course of the hearing, whether it's through written statements by witnesses or oral testimony, or frankly, even argument by the lawyers, I'm sort of indifferent to how that exhibit is brought to my attention. Anything that you bring to my attention, I will read and I'll consider. The question is, do you want me to read and consider other exhibits, which I have a copy, but nobody has referred to them? And I'm happy with whatever you want me to do. Just tell me, okay? So that you don't find yourself down the road saying, well, you didn't consider exhibit 22. Well, we agreed that I wasn't going to look at exhibits that nobody had told me to look at. Okay? So think about what direction you want to go on that in advance. As I say, it doesn't matter to me which direction you go, but I'd like to know.
No discussion about efficiency in arbitration would be complete without a discussion of expedited procedures. So let's take it away, Alex.
So most arbitral institutions have expedited procedures as part of their rules now. That includes the ICC, the ICDR, the CPR, and VanIAC. So VanIAC has it for both its international rules and its domestic. The international rules provide that for claims under $500,000 Canadian, they will fall under the expedited procedure threshold. And then the arbitrator has to provide their award within 45 days of that. And about a third of VanIAC's cases in the last 3 years have actually been under the expedited rules. Mm-hmm. And the key thing with expedited proceedings is you do have this intentional trade-off where for shorter time periods, it does impact the scope of the proceedings in return for the speedier outcome. And so entering into expedited proceedings with unrealistic expectations of scope can result in frustration across the tribunal, counsel, and the parties. And one of the most common issues that can arise in the dispute is that just because something is under 500,000 Canadian, or I think at the ICC it's under 2 million, doesn't mean the facts are simpler or that it's something that's possible to do in writing. And so that can end up costing more than the dispute is worth if you don't do it properly or you don't think of what's appropriate for expedited or not. And so this ties back into what Dana and Tom were saying at the beginning of the session, but sometimes matters that are the best suited for these types of expedited proceedings are simple breach of contract cases, where you're mostly doing a legal interpretation of the contract and the facts are not as contentious and you don't have credibility issues between the witnesses.
You know,
Well,
I think frequently what happens in these cases, particularly in a commercial context, somebody has written into their contract that any disputes will be resolved on an expedited basis under the expedited procedures of, let's say, the AAA commercial rules. The lawyers who are actually handling the case were not involved in that decision. And so they get the case and they say, this whole thing is going to be done within 30 days of the appointment of the arbitrator. They say, well, that was 40 days ago. Okay. So we've already blown through that. And so they adjust, and there's nothing wrong with that because the parties can agree to vary their contractual agreement anytime they want, assuming they agree to the variance. And so it is nominally an expedited procedure, frequently turns into a semi-expedited or a, expedited as best we can procedure. And that's okay. Just bear in mind that at some point, the parties thought some kinds of disputes should be resolved as quickly as humanly possible. And the arbitrator is going to look at it that way and do the best that she can or the panel can. But we're working with the lawyers in trying to do this as efficiently and quickly as we can. And that frequently results in some agreed variances from the nominal procedures.
We're at 11:30 right now, and we have one remaining question. I'll turn it to, this one is for Alex and Ludmila, but I'm sure our arbitrators would like to comment towards the end. It's from Gary Benton, and he says, I'm curious to see what Canadian lawyers think of arbitration in the US. Arbitrators, cover your ears. Chatham House rules. With experienced international arbitration counsel and arbitrators, he asks whether expectations should be the same. Wouldn't everyone anticipate that the IBA rules on evidence would guide the process? Is the US reputation for intrusive information exchange really a problem if an international arbitration is handled properly?
Going to defer this one to Alex because I think she's had a lot more experience with the cross-border. I will just say I have a feeling that part of the issue here is going to be who counsel on the other side is, as opposed to location necessarily. But over to Alex.
Yeah, I think that's totally right. So in all the cases that I've had actually go to hearing, we've had sophisticated US counsel on the other side. And by sophisticated, I mean they're sophisticated in the international arbitration space. And so they have not defaulted to the normal US litigation style discovery. Where you see more of the clash is where you have a commercial litigator or a domestic arbitration practitioner in the US, and then they want all those discovery procedures. And same thing with Canadian lawyers, right? If you have someone who's less experienced in the international sphere, they're going to want more discovery. So I think Ludmila's point is right. It's more so about who the parties are and who their counsel is, rather than I think where the location is. And the only other thing I'd say is where I see the most contention between that is actually in the drafting of the arbitration clause, where the US parties counsel wants to put in a bunch of stuff about depositions right in the contract from the outset. And then we have quite a bit of negotiations back and forth on that.
Thank you so much. We're at time now. I've saved a minute for a shameless plug for VanIAC and ICA's joint conference in Vancouver on the 2nd of June. I hope you join us here. The theme is energy disputes, energy infrastructure disputes, and international commercial arbitration. And we'll be hosting here in Vancouver. Thank you so much for joining us. Thank you to our esteemed arbitrators and counsel.
Thank you.
Thank you all.
Thanks, Elsa. Thanks, everyone.